Today, in response to Donald Trump's request for a mistrial on the grounds of the judge's and his court clerk's bias, Judge Arthur Engoron issued an order. The Trump legal team claimed in their request that the judge was biased because his law clerk had made more than the allowed amount in political donations for a single year, and that the judge publishes a high school alumni newsletter with links to articles about the case. First, the judge severely criticized the view that Trump's judicial expert, retired Judge David Demarest, had presented. The judge pointed out that although attorneys present their cases and judges provide decisions, it is unlawful and inadmissible for a party to provide an expert witness in an effort to influence the trial judge's decision about a motion. Judge Engoron, incidentally, pointed out that Demarest's petition contained erroneous legal language. Judge Engoron concurred with Trump that a court clerk is not permitted to contribute more than $500 to politics annually. The court did point out that the provision does not apply to candidates for judicial office, since his clerk is a candidate for the position of judge at this time. The judge further noted that when tickets to political events are subtracted, the judge's ruling does not apply, and her contributions still fall well short of the $500 cap. The court then made it clear that his clerk is only an advisor and that he bases each decision on his own discretion and understanding of the law. Judge Engoron continued, saying that the claim that he wasn't there to hear what Trump had to say, which Alina Habba and Trump had manipulated him into making in light of his lack of response to questions, was false and inadmissible because they had omitted the following sentence, "I'm here to listen to him answer questions." Next, the judge spoke to the alumni newsletter from their high school. He claimed to be the newsletter publisher and to have co-founded the Alumni Association for his high school in 2007. It includes noteworthy monthly actions undertaken by graduates, along with links to such events. He stated that there is no ethical restriction on what he did in the newsletter and that he did not compose any of the stories about himself that he linked to. The court ruled that Trump had already reached his decision on these matters and denied his request for an order to show cause, which would have required the Attorney General to provide a brief response